to Work This Way, a labor and employment law podcast. I am Tina Emerson. I'm joined here today with Maynard Nexsen labor and employment lawyers Jennie Cluverius, Christy Rogers, and Cherie Blackburn. Good to see you all.
Hey,
thank you for having us.
Good to see you.
Well, today we're going to cover the top labor and employment regulations and trends for 2024. And let's start with the importance of manager training. And Cherie, I'll start with you. Trainings from 5 years ago don't cover the discrimination and harassment issues for the modern day. Can you discuss the need for employers to stay up to date on those things?
Yeah, so this is a really important priority of mine when I'm talking to clients. I think two things have happened during the last 4 or 5 years. First of all, we had the pandemic, and so employers stopped doing the regular training that they would customarily give to employees because everybody was remote and everybody was focused on something else. And then the second thing is, in today's world, that regular training that focused primarily on sexual harassment and discrimination under Title VII is simply not enough. You've got to be able to take into account all the federal laws. It needs to address discrimination based on age, based on disability. You need to address requests for accommodations, for example, a religious accommodation or a disability accommodation. You got to make sure when you're talking about Title VII, you include the fact that gender identity and sexual orientation is now covered. And then one of the things that I talk about a lot is you need to make sure that managers understand, because they're the frontline people who are generally dealing with employees. I mean, all of us, Christy and Jennie and I, have had lawsuits where the manager is our primary witness. And so if that manager hasn't done what he or she needs to do when it comes to interacting with the employee, you're just setting the employer up for a potential liability in a lawsuit. But so I think it's very important that they know how to address issues under the ADA, issues under the Family Medical Leave Act when somebody needs leave. They need to know how to also deal with performance issues, because if there is a situation where an employee has an adverse employment action, let's say it's termination or maybe it's disciplinary action, and they claim that adverse employment action is based on their protected class, what the employer is going to say is no, it's not. It's based on your performance. A lot of the times, that's the reason. Well, if you look back and the first line manager or their primary manager hasn't dealt with any performance issue, you look back and you see their last performance evaluation is excellent, then that entire defense kind of just goes by the side. It's very difficult to convince a judge or a jury that that's the reason for the adverse employment action when there's not the documentation. So I'm a firm believer that the training needs to cover a very broad range, and it needs to be directly with those managers to help them be able to protect the company.
And when we talk about timeliness and keeping things up to date, just throwing out some recent NLRB decisions that can impact workplace policies, what's been going on recently that needs to make managers step up and pay attention?
So if anybody has been following with recent interest, which I'm sure you all have been, because the National Labor Relations Board is just the most interesting governmental agency ever, said with total sarcasm. But if you've been following any of these decisions, you'll see that the NLRB has kind of been going crazy, which happens on occasion, right? Especially when we see a shift in administration, we tend to see a shift in decisions and kind of the overturning of prior decisions, which of course make it so much more complicated for employers to ensure compliance. But the two big things I think that have happened recently with the National Labor Relations Board, the first is there is a new decision that was rendered by the board called Cherie cycle. And that's a case that addresses kind of how the National Labor Relations Board is now going to evaluate and assess employer policies, including those related to workplace policies, workplace conduct especially. And so the new standard now, which is going to be a little bit harder for employers, is that what we're trying to determine is whether or not the policy reasonably interferes with or chills an employee's Section 7 rights under the National Labor Relations Act. And so in doing so, what an employer is going to have to show is that if they have a policy that does in fact potentially infringe on those rights, the employer needs to show that, well, this policy is narrowly tailored, it is circumscribed in such a way that we are serving some kind of legitimate business interest in the way that we have this policy set up. And so I think the big one that I'm seeing that employers need to be aware of, and this may be something you need to consider when you're looking at revising your employment policies and that sort of thing, because this decision is actually retroactive in application. So if you have an employee handbook that is out of compliance, it doesn't matter that that handbook was issued before this decision came out. The decision is now saying, even if your handbook is a year old, it's still got to comply. But what we're seeing a lot is in these workplace conduct policies, right? I think we had a lot of employers, who had policies that said, hey, for employees, we want you to do the things that we would really basically expect all employees to do. We want you to communicate and act in a respectful way, be courteous to others in the workplace. And the National Labor Relations Board has said, policies like that are probably unlawful now. And I think that is kind of shocking, I think, to a lot of employers and a little scary. The second big thing that I think that's going on with the National Labor Relations Board is the General Counsel has issued a memo. This is not an NLRB decision, but it's a memo that was issued by the General Counsel where she has essentially taken the position that she believes non-compete agreements violate Section 7 rights. It's a little convoluted how she gets there, but she has basically encouraged the board to take this same position that non-compete agreements violate Section 7 rights. They essentially put employees in a position where they feel like they cannot get another job elsewhere to improve the conditions of their employment, things of that nature. And, she wants that to be kind of a retroactive application going, all the way back, several years, once all non-competes that have been entered into, to be invalidated. So that's just another one of those things we need to keep an eye on, but could have a huge impact for employers who have non-compete agreements.
Well, let's switch gears for a minute and talk about the ADA. What is it that employers might be missing some steps on? Jennie, we'll start with you. This is really a question for all of you. I'm sure there's a lot to offer here.
Sure. So the ADA, the Americans with Disabilities Act, is a law that we frequently see our clients get tripped up on. The FMLA is a law that everyone is well aware of, that's out there. And typically when you think of medical issues with employees in the workplace, your HR managers and employees themselves are thinking about the Family Medical Leave Act. However, there is an equally as important law, the ADA, that comes into play when you have employees who have medical issues or disabilities in the workplace that are impacting their ability to perform their jobs. One thing that we are seeing very frequently with supervisors, especially, is a failure on the part of the supervisor to recognize when an employee is requesting an accommodation of some sort in the workplace. The EEOC guidance is very clear that employees do not have to specifically use the word accommodation. All an employee really has to do in order to request an accommodation in the workplace is tie a work performance issue to some type of medical issue. So if an employee is habitually late to work and informs the supervisor that he or she is struggling with a mental health issue or with migraines or something of that nature, and that is impacting the ability of that employee to timely appear in the workplace for their scheduled shift, that employee has requested an accommodation. Many supervisors fail to recognize that that is the case and fail to properly escalate those requests to human resources so that human resources can begin the interactive process of trying to determine if that employee is entitled to an accommodation of some sort in the workplace. So the just basic identification of an accommodation request is something that we are really seeing employers struggle with. In addition to that, a lot of employers think that once an employee has taken 12 weeks of leave under the FMLA, that employee is not entitled to any further leave due to a medical condition. Well, the ADA says otherwise, potentially, with respect to individuals who are qualified individuals with disabilities who may require some type of further leave that would ultimately enable them to come back and perform the essential functions of their job. So those are two areas where I'm seeing employers frequently miss the application of the ADA and then find themselves in some hot water with the EEOC.
Another thing that I think we see a lot deals with the interactive discussion that you have to have with an employee under the ADA. A lot of times when I get a call from an employer, my client will say, we've received a request for an accommodation, we have analyzed it, we've made the determination that we cannot provide this accommodation. Maybe it's continued leave and they've already given leave. They could have given leave beyond the FMLA. And so they have decided we are not going to be able to provide the accommodation, and they're calling just to run that by me. And first, I applaud them for calling to run it by me. What happens a lot of times, though, is they have missed the interactive discussion. And the ADA actually requires that an employer have that interactive communication with the employee. And it's interactive, which means you have to sit down with the employee or discuss with the employee what kind of accommodation they need. Maybe it is additional leave and the employer has said, well, we can't give that. Well, you've got to sit down and say, is there anything else? Is there any other accommodation that you can think of that would allow you to perform the essential functions of the job? And if they don't have that truly interactive discussion, they've missed a step under the ADA. And we see lawsuits that claim violations of the ADA that will have a separate cause of action for failure to have the interactive discussion. So that's a key area that employers need to keep in mind.
That's really interesting. How about you, Christy?
Yes, I think the other big one that I see a lot is kind of missing the last step in the process, right? So we've kind of had the beginning, the middle, and now the end. And the end of that process is that a lot of employers forget about the reassignment obligation under the ADA. So when we're looking and we're talking about accommodating an employee, our obligation is that we look first to the job that they're in. And we say, okay, based on the current job that you're in, is there anything that we can do to accommodate your disability? And a lot of employers, I think, once they've done that analysis, they assume that's the end. And it's not, because if we can't accommodate in the job they're in, our next obligation is to look outside of that job to see, is there another position that we could put you in, right? And that job has to be open and vacant. It's got to be an equivalent or downgrade position, and it's got to be a position that the employee is qualified for. But we want to make sure before we medically separate someone for an inability to accommodate a disability that we've gone through that process of looking at reassignment to see, is there another job out there where we could put the employee that would accommodate that disability?
Interesting. And what happens, just from a layperson's perspective, what happens when they are unable to find that position?
That's a great question. I think there's a misconception that people think, well, if we've gone into the reassignment process and we can't find a job and the reassignment process is unsuccessful, that means there's a possible violation of the ADA. And that's actually not the case. Just because we're unable to find another job doesn't mean that there's a liability on the employer's part. Obviously, as with everything under the ADA, it's a little complicated. And there are certain things that we certainly want to demonstrate that we've done, right? That we've looked for a job. These are the kinds of jobs we've looked for. We've looked for a certain period of time. We've potentially given the employee an opportunity to also look for jobs and express an interest in positions. Just because that reassignment process fails doesn't mean there's liability under the ADA, but not performing that reassignment process, not looking for those other jobs, could certainly give rise to liability if the employee can prove there was another job you could have put me in as an accommodation.
Okay. And now what about pregnancy accommodations? That seems like a temporary accommodation, but how does that work?
Right. So there's actually been some recent legislation as it relates to pregnancy, and I'm sure most employers have heard about it. We've got the Pregnant Workers Fairness Act, which essentially requires employers to provide reasonable accommodations to workers who have known limitations due to pregnancy, childbirth, and other pregnancy-related medical conditions. This is a newer law, and there are currently some federal regulations that have been proposed to kind of interpret interpret this law and give employers some additional guidance with regard to this law. But I think a couple things to bear in mind that I think are most important with respect to this law is that, first of all, when we talk about known limitations under this law, that is going to be much more broadly defined than what we think about in terms of disability under the ADA. So someone who is pregnant is not required to prove they have a disability as that is defined under the ADA. This is going to be much broader. With regard to accommodations, I think it is also going to be more difficult for employers to prove that there's an undue hardship in providing the accommodation. And so far, the guidance that we've seen from the EEOC has made clear that they also believe it's going to be harder for employers to prove an undue hardship for the reason you just mentioned, Tina. It's a temporary situation, right? So doing something for a finite, shortened period of time, it's a whole lot harder to prove that's an undue hardship on you. The other big thing that we've learned so far in terms of these regulations is that there are certain things, if these regulations are passed, there are certain things that are considered a per se reasonable accommodation if requested by an employee. So in other words, under the law, we're saying it's automatically considered to be a reasonable accommodation if the employee needs additional restroom breaks, if the employee needs to be able to sit and stand alternatively throughout the workday, if the employee needs to be able to have water, access to water, at her working station. Those sorts of things are going to be considered reasonable just on their face.
And we talked about the temporary accommodation of pregnancy. Then there are longer term accommodations like religious ones. So tell me a little bit about your experience there, Cherie.
So it's interesting because requests for religious accommodations and discrimination charges and claims based on religious beliefs have been on the rise in the last few years. And so one of the things to keep in mind, just when you think about where does this come from, so Title VII of the Civil Rights Act says you cannot discriminate against anyone based on a sincerely held religious belief. It also requires, though, that the employer accommodate an employee based on a sincerely held religious belief unless it creates an undue hardship on the employer. And keep in mind that a sincerely held religious belief is very broad. So the courts have said it's not only your organized traditional religions across the world, but it's also unorganized, it's uncommon, it's even incomprehensible. So they've even said you may not understand it, but it could be a religious belief. I mean, one example is Wicca is recognized sincerely held religious belief, but there's others that employers may have not even heard of. So you have to keep a very broad view of it when someone does make a request for a religious accommodation. So what the employer has to look at is, does it create an undue hardship? And it may be a request to work, not to work on particular days. It may be a deviation from the dress code. It could be a change in your schedule, lots of different types of requests. So in the past, the test for an employer has been, does it result in more than a de minimis cost for us to implement this accommodation? Well, there was a case in June of this year that went up to the U.S. Supreme Court. It's called Groff versus Joy. And what the U.S. Supreme Court said is, we're going to reject that de minimis standard. That is no longer the test. Going forward, to show an undue hardship, an employer has to show a substantial increase in cost based on that request for an accommodation. So very different from de minimis. I mean, de minimis is basically just very nominal, whereas substantial increase in cost is substantial, significant. And what the court also said is that in making that determination, you've got to look at that specific factual scenario on a case-by-case basis. You have to look at the request for the accommodation, the effect it has on the operation, the size of the operation, the total revenues involved, basically, in the organization. So this will make it particularly hard for some bigger employers, because whatever that cost might be for that one employee making the request for the accommodation, it needs to be considered along with your entire revenues, budget. It definitely raises the bar for all employers in considering what is an undue hardship. It's not quite to the level of the ADA yet, but I think it's going to take us several years of case law, following this decision to see, and I think you will continue to see increased cases and complaints based on failure to accommodate based on a sincerely held religious belief.
And as usual, things are always far more complex than they appear on the surface. So we're going to switch topics completely and move on to a more technical issue, AI. So that is something that people are either afraid of or excited by. What can we expect, Jennie?
Sure. So everyone is talking about AI. President Biden even issued an executive order on AI recently, which included provisions on use of AI in the workplace. The EEOC has recently issued guidance addressing that as well, including how the use of AI in the workplace intersects with Title VII, which is the federal anti-discrimination law that prohibits discrimination on a number of bases. And it applies to a great many employers in the country. AI is an area where technology is rapidly developing, and the types of AI that employers are using today already include tools that allow them to sift through thousands sometimes of job applicants very quickly in an automated manner and decide which of those applicants they're going to bring into interview. Employers are also using AI to do things like determine who within their organization needs to receive a pay raise, who they need to promote. So again, the technology is developing rapidly in this area. Most employers, whether they know it or not, are using some form of AI in connection with their HR practices. And as is frequently the case with new technology, we are going to see a time period where the law is lagging behind those developments. And in fact, it may be a permanent state with respect to use of AI in the workplace. We've seen this in the past with other technologies, and it is a challenge that employers are going to face as the law struggles to keep up with the advent of this new technology and how it is being used. So we will have much more in the future to discuss on AI, but for now, employers definitely need to be taking a look at their policies contained in their handbooks and their practices with respect to the use of AI and trying to ensure that it doesn't have a disparate impact on any protected categories of workers in their workplace.
So the lesson there is really just try to be more proactive than reactive, even though we're in wait and see mode.
Yes, and stay tuned because we will have future episodes that dive in a little bit more on the AI issue and give employers a little bit more to work with as far as, things that they need to be considering and doing moving forward.
Great. Well, that's a great place to end this episode. Thank you, ladies, for being here today and sharing your thoughts on what's to come in employment law. Thank you so much for being here, and we will see you next time on Work This Way.